One of the problems with estate planning is it's not something that's urgent. Nobody thinks they're going to die today, and so it's something we can do tomorrow and it'll be all right. Well, I'd like to tell you that's really not the case because nobody knows when they're going to die or become incapacitated. It is important to have your plan in place for that event to happen, just in case. Let me tell you a story about a lady that came to see me to have an estate plan created. She wanted a living trust. She wanted to avoid probate. She wanted to supervise how her estate would be transferred to her heirs. And she had her ideas about what she wanted to do. We met. I took some notes, prepared her documents. We called and told her things were ready for her to come in and review. She said, well, I can't come this week. Maybe I'll come in 2 weeks. And then 2 weeks came and she decided she could put it off another week. We didn't hear from her and we never got a response to our later phone calls. And so I did not know what happened to this lady. But about 6 months after I had her trust prepared for her, she came in to see me. And here's what she said. Mr. Allen, I wish we had signed that trust that I know you had prepared and it was ready for my review and signature. But before I did come in, I was involved in a terrible auto accident. I was in the hospital for several months, and I didn't know what was going on. I have a friend, a neighbor, who knows when something is wrong at my house. He saw that things weren't being taken care of, the mail was not being picked up, and so he found out that I was in the hospital. And since I was in the hospital, there needed to be somebody to make medical decisions on my behalf. And so he talked to his friend, an attorney, and they decided they would have to apply for a conservatorship down at the courthouse. So they did. They applied for the conservatorship. Her neighbor was named the conservator to take care of paying the bills and making the medical decisions on her behalf. And then the court decided, since she had several assets, that the attorney would be instructed to prepare a trust under the direction of the court and name a local bank to be the trustee. And so that was done, and all of her assets were placed under the control of this trust. Well, my friend, the client, I'll call her Mrs. Banks, was able to revive and recovered. And so this is when she came to see me. And she said, Mr. Allen, when I went back home and I found that my Cadillac had been sold, all of my furs were placed in storage somewhere. I didn't know where my jewelry was. My bills were being paid, but I didn't know what was happening with my investments. So is there some way that we can get things resolved? So I told her, well, somebody must have been named the conservator, and that's when she brought out the court papers showing that her neighbor had been named the conservator and a bank had been appointed the trustee over all her funds. So I said, yes, we can actually get this set aside. We can go back to court, show that you've recovered, and then we can have your trust that you've already had prepared. We can put that in place, and then everything will go according to your plans. And so to get that conservatorship set aside, she had to get approval from her doctor. When she visited him, he asked her some questions that were kind of confounding to her, counting backwards, asking her dates and names that she wasn't quite sure of anymore. And so the doctor didn't feel like he could sign a letter saying she'd recovered. And at the hearing down at the courthouse, even though the judge could ask her questions and see that she was mentally stable, because the doctor hadn't signed this letter, he was reluctant to set aside this court-appointed trusteeship. And so things continued that way. The bank continued to have control. The neighbor continued to pay the bills. Well, Mrs. Banks had a broken heart. She could not get control over her estate any longer. And she died about 3 months after this. I think that one of the reasons for her death was a broken heart and a broken spirit over not being able to have full control. The sad part is, if she had only been able to come in before her accident and sign the trust that was prepared for her, the medical power of attorney and the financial power of attorney, everything would have been done according to her plans, and it would have allowed her to continue on. I think that maybe she would still be alive because she'd still have control over her assets. So the thing that you learn from this is you never know when your time is up or when you're going to have an unforeseen accident. So you need to have your plans in place, have them prepared before such an occurrence. And so the thing is to make sure that you have done your planning. Now, to give you more help on understanding this, you might want to go to livingtrustdoctor.com for more information.